May 25th, 2018, the Supreme Court of Texas makes a decision, and it's a decision that you're involved in. Tarr versus Timberwood Park. You're representing Mr. Tarr, and the Supreme Court decided unanimously in favor of your client. So this is something we stumbled across this case when we had an issue with a developer up for an Airbnb that we had, and my wife was doing some searching and she found this case. I'm like, and I read the whole summary. I'm like, holy cow, this is like, for the most part, very similar to the situation we're going through. And I was like, this is landmark in Texas, and most people don't know about it. So what makes the Tarr versus Timberwood Park a landmark case for Texas property owners that are using their properties for short-term rentals?
Well, you're correct, Chris, that it is, first of all, it's landmark. Second, it is not widely appreciated. And I am still getting calls from people who say, I just got a letter from my HOA saying I can't rent for short terms. And when I read the HOA's reasoning, it's clear they have not seen the Tarr opinion and have not consulted an attorney. So Ken Tarr and his wife, like many people, have deed restrictions that say you can only use your house for residential purposes, and you can't run a business out of the house. Well, that's not surprising. Nobody thinks you can operate a gas station or a convenience store or something from your house. But what people who don't like short-term rentals are saying is that your house is a business just because someone stays there less than 30 days. So there's some magic, or sometimes they say 90 days. They don't always give the same answer, but there's some magic number of days that converts a house from residential to business. So what the Supreme Court said in Tarr is, first of all, a short-term rental is just a rental. You're not talking about anything different. The fact that someone is there for 29 days versus 31 days has nothing to do with the fact, or has nothing to do with whether the way the people live in the house is residential. So that's the first and probably most important thing. That is, residential encompasses short-term rentals. They're not a business. The second most important thing, and this is where you'll see Tarr over the years, I think, really get steam, is that it said when deed restrictions are silent about something, that doesn't mean that that something is restricted. So what the HOA in Tarr was arguing is that because the deed restrictions say nothing at all about the duration of time that someone can stay in a property, that somehow that's a ban on what the HOA called transient use. So they use this word transient to suggest that drifters and hobos and dangerous people are staying in houses, and you see that all the time. But the Supreme Court said, no, there's nothing, we're not going to read into a set of restrictive covenants, which almost everyone has, some new word that you think the drafter left out. So silence is not a restriction.